Hello, everyone, and welcome to Uncivil Law. I hope you are having a fantastic day. I have, of course, been visiting my friend Leonard French in Pennsylvania, and I've driven back for the last 4 hours, and I'm now back home, and I'm now going to record my session for you guys. Don't want to deprive you of your Uncle Blackleaf time. We got 5 stories, some that will enrage you, some that will make you happy, and some that are just pretty silly. So we got a lot of stuff going on today in the stories, and I think you will enjoy our content. Give a chance for everyone to come here before we get started. Thank you, Little Pink Browser, for coming. Glad to have you. Hello, Leaky Glock. Nice to have you here. Hope you're having a great day. Who else is present? Any of my regulars present? Lint is here. Hello, Lint. How are you doing? Good to see you, sir. This would not be a stream without you. Seindinger is here. Excellent. Very good. Glad to have you here, of course. Riley's. Good day. Hello. Hey, you drove all the way home? Yeah, I did drive all the way home. Yes. It was like 3.5 hours, 4 hours, but yes, I did drive all the way home. So, I had enough gas, just nonstop. No problem. Eva Coleslaw says I'm in here and I might be in and out. That is fine. I understand. Hello, Midnight Rose 07. Yay, Uncle Blackleaf. Yay, Uncle Blackleaf, indeed. I'm here for your Uncle Blackleaf needs. I've got a really good story for our last story today. I thought about a lot about the ordering of stories because sometimes I don't do that very well in ordering. So I put the really silly story last. So for those of you who are here to the end, I have just one word for you. Smurf berries. Good times. Okay. Well, we are 2 minutes past, so we will go ahead and get started, and more people who join will join, and we will be happy to have them here. Of course. Let's get smurfing along. Yeah, I know. I know Uncle Blackleaf loves the people being stupid ones. Well, we got some stupid, we got some stuff that's going to enrage you, and we got some plain old silly today. And we got starting with some unfairness for our first story. Unfairness always makes us grumpy. Hello, everyone, and welcome to Uncivil Law. For our first story today, we have the story of Rafif versus Oakland County. We are going to review the case from the Court of Appeals for the state of Michigan. This case is currently on appeal to the state Supreme Court. We do not have a decision yet, but we can read the decision below. In this case, a person's house was seized by the government because the person failed to pay $8.17 worth of taxes. The government sold the house out from under him, and then they kept all the money for the house. So he's not only out his $8.17 that he owed, but the tens or hundreds of thousands of dollars that his house cost. Rafif thinks that this is unfair. The court below did not think it was unfair. We're going to read the court decision below and try to understand the reasoning from the Court of Appeals. So let's get started with that. Each plaintiff owed property on which the defendants foreclosed because of tax delinquencies. The trial court found no such violations and ruled in connection with a motion for judgment that the plaintiff had forfeited their properties in the entirety. On appeal, the plaintiffs first argue that the statute is unconstitutional on its face because it violates the due process guarantees by prescribing insufficient steps for a government entity to take what it knows it has efforts to take. The Michigan Supreme Court ruled that where notices of tax delinquencies were returned to a county treasurer as undeliverable, the county was not entitled to proceed with foreclosure without taking reasonable follow-up methods. The court noted that reasonable follow-up measures directed at the possibility the addressee had moved would be to post notice on the front door or to send out notice to the address to the occupant. The court also pointed that although the government must take reasonable additional steps to notify the owner, it is not required to go so far as to search for the owner's new address in the phone book and other government records such as income tax rolls. Yes, heaven forbid the government be inconvenienced by having to look at, for example, DMV records or other records of the government that might give an indication as where the person moved to. And why is someone texting me 3 different times? Yes, heaven forbid that the government be forced to look at DMV records or other records that might give indication of where a person had moved to. Heaven forbid they do a basic records check of their own databases. Hold on. Okay, Lint, I just wanted to know that I changed the threshold to 12 characters for caps because it was being too aggressive. It was 5. I changed it to 12, and you still tripped over the 12 of all caps. So maybe I should just delete Nightbot altogether. It doesn't seem to be helping. Plaintiff argues that the statute falls short of the requirements of the prior law that foreclosing government units take additional steps when they know that they have attempts to serve notice have failed and therefore is unconstitutional on its face. However, the statutory provision is not unconstitutional on its face unless there are no set of circumstances under which it could be applied constitutionally. So here the court is alluding to the difference between a facial challenge and an as-applied challenge. When you're bringing up an objection to a statute facially, you're saying that on its face, it is illegal. When you're bringing it as an as-applied challenge, you're saying as it applies to you, it's illegal. So here the court is noting that a facial challenge does not succeed if there's any constitutional means of applying it. The statute does not authorize proceedings to foreclosure when notice consists of a single attempt at mailing that is known to be failed, but rather it specifies alternative means of identifying a valid address, mandates personal visits to the subject property, and sets forth requirements for notice by publication. We therefore reject the claim of facial unconstitutionality. We therefore reject the plaintiff's claim of facial unconstitutionality. So far, so good. The statute does appear to be facially valid. But what about as applied to this person? Let's read more. Plaintiffs next argue the statute, as applies to each plaintiff, resulted in a deprivation of constitutional due process. We do not agree. Well, so much for that as applies challenge. Oh well. We note that under the statute, the failure of the foreclosing governmental unit to comply with any provision of this section shall not invalidate any proceeding under the Act if the owner of the property interest or a person to whom a tax deed was issued is accorded the minimum due process required under the state constitution and the Constitution of the United States. Hello, Joe. Nice to have you here. The defendants did not simply rely on the mailing address they learned when it was ineffective. Ralph Fifi had paid taxes in 2012 and 2013 in response to notices of deficiencies sent to its address, as indicated on the subject property deed, but a third such notice prompted no such response. Apparently, defendants had no reason to doubt that the address ceased to be effective, but for the lack of response. That literally makes no sense to me. Just because the address was valid in prior years does not follow it's valid this year. I don't know what the court is talking about. Additional steps then included a personal visit to the property where notice was left with a tenant, plus identification of a residence agent and notice sent to Laura-Fifi's at an agent's address. Well, that does seem to be a little bit more promising. They gave notice to someone who was at the property and apparently sent it to some formalized agent as well. So that does seem to be enough process in terms of notice. Plaintiffs identify no major misstep on defendant's part when they complain that notice was sent to the corporation's identified resident agent's address was addressed to the corporation instead of the agent. Yes, if you're sending notice to the place where notice is supposed to be done, the fact that you put the corporate name instead of the agent name does seem to be like neither here nor there as far as notice goes. The efforts defendants undertook to serve notice on Laura-Fifi satisfies the minimum requirement of due process insofar as the notice was intended to advise the corporation of tax liabilities and its property would be subject to foreclosure proceedings to satisfy the liabilities. Midnight Rose, it does look like they gave personal service. Maybe I wasn't clear, or maybe you're misreading, or maybe I'm misreading it, but it says here the additional steps then included a personal visit to the property where notice was left with a tenant. Now, so I guess they're giving, but that's usually like considered sufficient notice. You know, you're giving notice to someone over 18 who can deliver it to the person in charge. So that would typically qualify as personal service delivery to this. I mean, it's the property in question. It's a person over the age of 18. It's normally considered sufficient, but you know, anyways. I guess the tenant failed to forward it on. Oops. The validity of the foreclosure depended not on perfect compliance with the statute, but on satisfying minimum constitutional due process requirements. By pointing out the defendant's agent failed to arrange for a return receipt in connection with the notice sent by certified mail, plaintiff essentially admits defendant had no reason, but for the lack of response, to doubt the attempted mail service was successful. Regardless, to the extent the United States Supreme Court admonishment that when mailed notice of a tax sale is returned unclaimed, the state must take additional steps to attempt to provide notice, so the qualification is that additional steps are required only if it's practical to do so. And as was the case with regard to this plaintiff, the plaintiff specifies no additional steps that might have been taken that would have better provided with notice. And that is a bit of a fatality to the argument. If you can't even provide hypothetical things that should have been done to provide you better notice, then you can't argue that enough wasn't done. So that does seem to follow. Plaintiffs next argue that defendants' administration of the statute's show cause hearing requirement allows them to play judge, jury, and executioner without any sort of procedural safeguards required by the due process claim. Plaintiffs contend the show cause hearings deprive the delinquent taxpayer of a meaningful opportunity to be heard, and we agree with the defendants that plaintiffs do not have standing to raise the issue. Why? Because plaintiffs did not participate in any show cause hearing below, and so suffered no injury from the manner in which such hearings are conducted. And that does seem to logically follow. Often in administrative processes, the processes that are given are much less formal than a court, but you can always appeal those decisions to a court, and you have to participate in those decisions, the same as they were anyway. So you would participate in the show cause hearing, and if you lost, you have the right to appeal that decision. But if you don't show up, then you basically forfeit your argument, because you never gave the government a chance, you know, you never gave the government fair notice that you had a problem with it. So you can't just say, well, this hearing doesn't give me notice or it doesn't give me due process. If you're unhappy with the results of the hearing, you appeal it through a court process. You can't just not show up. So that part does make sense. Usually you have to follow the administrative process and then go to the court if you're unhappy with the administrative result. Further, plaintiffs explain neither how they came to understand how defendants normally conduct such business, nor why they're so certain, had they appeared for their show cause hearing, defendants would have prevented them from exercising their statutory right to show cause in fact. Yeah, I kind of agree with the court analysis here. I don't know how you came upon this apparent knowledge, and you can't say they wouldn't have given me process if you don't give them a chance to give you process. You can only complain about actualities, and you didn't even give them a chance. So, that seems fair. In addition, plaintiffs have missed their opportunity to participate in a show cause hearing in connection with the respective parcels rendered moot any question concerning how well such a hearing would have comported. A case is moot when it presents only abstract questions. Yeah, same analysis. Again, we don't have to analyze whether or not it would have been sufficient. You didn't even participate at all. So the whole thing is rendered moot by your own lack of participation. So that was a major oopsie on your part. Yeah, I know, Lint, right? Yeah, all you heard from the headlines is how they were cheated out of $8.17. But you go read the case, and a lot of this is like, oh, no, it's not that way at all. Now, we'll get to the fine issue, because I still think that's valid, but the due process issues, I don't have any sympathy with them on the due process issues. It looks like they actually did have notice in fact. So it's not even like we didn't have notice in fact, because they were aware of the hearing to not participate. So it's like, yeah, you didn't give us notice the right way, but you actually had notice in fact. So, okay, yeah. Because plaintiffs suffered no injury relating to how the defendant's conduct show cause hearing, and one can only speculate concerning what might have transpired had they appeared for one and demanded their rights, the issue is moot. Plaintiffs next argue that the statute is unconstitutional because it mandates that government entities retain proceeds beyond those required to satisfy the delinquent tax bills. They argue that therefore allows unconstitutional takings. We disagree. This line of argument is significantly more promising. The United States Supreme Court has recently held that the excess fines clause does apply to the states, and so one could view this as an excess fine. He owed $8.17 on property. It's reasonable for the government to seize the property to pay that tax bill, even though it's $8.17. If it were 1 cent, they could do it. Whether or not they get to keep the excess is a whole nother set of problems, and one could view it as an excess fine in light of recent Supreme Court precedent. So I think this is a more promising line of argument. Let's see what the court says. Hello, Crimson J. I'm glad you're here too. This issue is easily resolved by reference to a case called Bennis. In Bennis, the court set forth the following summary. The petitioner was a joint owner with her husband of an automobile in which the husband engaged in sexual activity with a prostitute. A Michigan court ordered the automobile forfeited as a public nuisance with no offset, notwithstanding the lack of knowledge for the activity. We hold the Michigan court order did not offend due process clause of the 14th Amendment or taking clause of the 5th Amendment. While this is very relevant U.S. Supreme Court precedent and is directly on point with the example, I would take note that it is questionable whether or not it is still valid in light of the Supreme Court's recent guidelines and recent decisions when it comes to the excess fine clause as it relates to the states. The recent decisions from the U.S. Supreme Court, in fact, from this term and last term, somewhat undermine the United States Supreme Court's decision from 1996. So if I were looking at this case, I would say that this holding is questionable as to whether or not it still has legal validity in light of later cases that follow. So while on the surface it appears to be on point, at least in my opinion, later cases hold it as questionable whether or not it is still good law. Defendants obtained the property by way of a statutory scheme that did not violate due process. The Constitution does not require them to compensate plaintiff for lawfully obtained property. And this probably will seem very familiar to the case where we discussed the police people who basically put so many holes in a home during trying to get a burglar out that they, caused so much harm to the home had to be destroyed. It's not eminent domain taking. It's taking for police action. And so there's typically no compensation that is required for that under the current case law. But because the amount here was so minimal in value of the property and the excess fine clause, I think that the upper court may re-examine this. I think that's the end of the case. Yes, it is. So that is the end of the case of Rafifi versus Oakland County. In this case, we learned that a property owner had a delinquent tax bill of $8.17. In order to recover for this tax bill, the government seized the property, foreclosed on it, sold it, and then kept all the money from the house. We learned that he complained that there was lack of due process. We learned that this argument did not hold water. It looks like he had notice in fact and decided not to participate because he thought it was a sham. But he has to give the government an opportunity, and he has to find out for a fact it's a sham. If it was a sham, he would have had all the standing in the world to appeal that to a court because it was a sham process. But he didn't even participate. And so the whole issue is rendered moot by his own actions. So that was a bad move on his part. As to the excess fine issue, I think in light of current Supreme Court precedent, the 1996 case from the U.S. Supreme Court is questionable as to whether or not it is still good law. So I think that the upper court, when looking at this and looking at the excess fine clause, may take cause to re-examine this. And we will see what happens because I think it's a very interesting interaction on trying to form new law. So we will see what happens next. Hello, Tactical. It's nice to see you. Thank you for joining us. Tactical, can you stay with us a while or do you have to go? Because I want to know whether or not you want to, who the whole thought was a good idea to seize a house over $10. I mean, if you won't pay, you won't pay. It's it's an asset. You have to go make dinner? Oh, man. Make me dinner. All right. In light of Tactical not being able to be here long, let's do the story that is going to piss everyone off. So that's always exciting. Spoiler alert, the police have no affirmative duty to protect you. So that's where this is going, FYI. Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision from the Court of Appeals for the Fifth Circuit. This is the case of Vinnie Cook versus the city of Dallas. In this case, a person made a 911 call in a frantic panic because their ex had come to their house to harm them. The police decided not to do very much about it. The person who was on the 911 call was killed. Their estate is very unhappy at this and is suing the police because they didn't do anything about it. Unfortunately, as the plaintiff is going to learn, the police have no duty to protect you, and so there is no liability for the police, even though they ignored the 911 call. So let's hear about this and see what happened. Yeah. This is not new law. This is old law. This is why the Second Amendment people think we have a right to bear arms. Everyone says, why not just call the police? Here's why. We don't think that's a viable answer. This appeal arises from Deanne Cook's 911 call to report a domestic violence dispute, the Dallas Police Department's response to that call, and Deanna's tragic death at the hands of her abuser. The plaintiff has sued the defendants, the 911 call center, the police dispatcher who made the call, the 911 call, the police officers who responded to the call, the police officers who responded 2 days after the person had died, and they're alleging violations of 42 U.S.C. 1983. Let's talk a little bit about the factual background that led to this event. On Friday, August the 17th, 2012, at 10:54 a.m., Deanna, a 32-year-old mother of two, called 911 to report she was being attacked in her home by her ex-husband. Deanna had previously called the police to report the ex-husband's domestic abuse and harassment, both before they were divorced and after the divorce was finalized. Hello, Brendan Bush. Nice to have you. On the call, Deanna was screaming at the top of her lungs in fear, crying out for assistance, and screaming, "Help, please stop it," to her attacker. Deanna did not provide her address to Hopkins, the 911 dispatcher. Hopkins claims that because Deanna had called from a cell phone, Hopkins could not immediately retrieve Deanna's address, so she enlisted Wakefield to help find the latitude and longitude of Deanna's location. Although by law in the United States, all cell phone providers are required to provide E911 locations for exactly this purpose, not all 911 centers are capable of receiving the data. So even though by law the cell phones are required to transmit location data to solve this problem, the 911 centers themselves don't necessarily have receivers to receive the data. So that seems to be where we are in this case. Fun. Nearly 10 minutes after the call began, Hopkins notified the police dispatch, classifying the call as a major disturbance. Hopkins added the comment, "Urgent." A 10-minute response time in order to find the address is pretty good under these circumstances, so one of the many reasons the police ask you to give a location of your emergency when you call, so they don't have to go through this, because minutes matter. Wakefield, a fellow police officer, instructed Hopkins to hang up the call and to call back after the call went dead. The call went to voicemail. Hopkins did not follow up to ensure that police dispatch had actually sent officers to the residence. Mitchell was the police dispatcher who had received Deanna's. Mitchell was the police dispatcher who had received Deanna's location that day. She allowed police officers to volunteer for the call despite it being marked urgent. McEnana and Wilburn, City of Dallas police officers, volunteered to go to the residence. On the way, the officers stopped at a 7-Eleven for bottles of water. Perhaps not being taken with the urgency the situation perhaps required? Approximately 50 minutes after Deanna called 911, the officers arrived at Deanna's home. They knocked on the door and had the dispatcher call the cell phone, which went to voicemail. They avoided entering the home from the back entrance because they heard dogs barking. When officers didn't get a response, they left the residence and noted that the disturbance had been resolved. Okay, well, I don't know if that qualifies as resolved, but that's how they marked it in their system. Brenda Bush says, "Do you always do Sunday streams?" Yes, I do. I normally do them on Twitch at 1 o'clock-ish, immediately following Leonard French's stream. But today, I was with Leonard French in person in Pennsylvania, so I wasn't at my equipment to do my stream. So I'm doing it now because I wasn't available later. I just drove 4 hours from Pennsylvania to be with you guys, okay? And because I don't have as many followers on Twitch as I do here, I decided to stream on YouTube, so that's what we're doing. I'm streaming it on YouTube because I can. But yes, I normally stream on Sundays, but I normally stream on Twitch. Twitch.tv/uncivillaw, if you want to follow me there. The plaintiffs went to Deanna's home 2 days later on Sunday, August the 19th, after Deanna had failed to show up for church. They noticed her 2 chihuahuas barking and water leaking from the home. Her mother, Vicky, called 911. She told Vicky that no police officers could help. Plaintiffs then kicked in the patio door of the residence and entered Deanna's bedroom, where they found Deanna deceased, her body partially in the bathtub. Everyone can just call 911 when they need help, right? No, not so much. Not so much. It didn't end well for Deanna. Yeah. Yeah, the Supreme Court has ruled on this situation many, many times. Castle Rock versus Gonzalez, Warren versus DC. There's about a bajillion cases that say the police have no duty to protect you. This is going to be another case that says the police have no duty to protect you. This is not a new thing. This is old shit. Old shit. Yeah. Let's see. The Dallas police chief, Brown, suspended Hopkins under the department policy. They should have not asked the person to call the prisons and hospitals before sending people to the address. The police chief admitted that the 911 operator obviously failed and it caused the life of Miss Cook, and the mayor stated that our safety net wasn't there for her. The police feel slightly sad about this. Aw. Police sued the defendant in federal court, bringing a 1983 claim under various claims. The individual defendants all filed motions to dismiss, and the district court dismissed all the claims. The district court granted the city's motions for summary judgment on the municipal liability claims based on the proposition of City of Los Angeles that a municipality cannot be held liable if plaintiff cannot show a constitutional deprivation has occurred. Because the district court already held that none of the individual defendants had violated their rights, the court held there was no claim. So under 1983, the government is only liable if they violate your constitutional rights. Unfortunately, the Constitution only provides negative liberty. That is freedom from the government. The Constitution does not require the government to do pretty much anything. So it is not a violation of your constitutional rights for the government to do nothing. It is unfortunate, but is not a constitutional violation. So no 1983 violation. Plaintiffs contend the district court erred in dismissing their due process claim against the individual defendants and the city. But the Supreme Court has held that due process clause generally confers no affirmative right to governmental aid, even where such aid may be necessary to secure life, liberty, or property interest, DeShaney versus Winnebago. And the failure to protect an individual against private violence simply does not constitute a violation of the Due Process Clause. McClendon versus City of Columbia, quoting DeShaney. I could also cite Castle Rock versus Gonzalez or DC versus Warren for these same propositions, but it is very true. The United States Supreme Court and the courts have long held that police have no duty to protect you individually. If the police do nothing, it is not a constitutional violation. So you call 911, you have a restraining order, the police do nothing. Oh well, it is not a violation. You can't sue the government. They have no affirmative duty to protect you, even where your life is on the line. Yeah, this is not new law, right? This is not new law. But it is still like people get surprised by it every time. There are certain limited circumstances that, however, are an exception, with a special relationship that does pose an obligation on the state. For example, limited circumstances are instances where the state has affirmatively exercised its power to restrain individual freedom to act on their own behalf through, for example, institutionalization, that's a hard word, through incarceration, institutionalization, and other similar restraint of personal liberty. So what the court is talking about there is that while the government has no affirmative duty to protect you in general, there is an exception to this rule. The exception is if you do not have the freedom to protect yourself. And that situation would be, for example, if you're in prison or otherwise being detained by the police and so cannot exercise your own self-autonomy. In those circumstances, the government does have an affirmative duty to protect you. How good that affirmative duty to protect you in prisons is a whole nother set of problems. I would refer you to the recent Jeffrey Epstein issue. The complaint does not allege that any of the defendants affirmatively acted to restrain Deanna's personal. The complaint does not allege that any of the defendants affirmatively acted to restrain Deanna's personal liberty in a similar way to incarceration or institutionalization. Yeah, you know, I'm just going to turn off Nightbot. Hold on. Hold on. Okay. Nightbot is now disabled. You should now be able to do whatever you want. Let's see, where was I? Yeah. Please don't make me regret it. It is true that Deanna may have a viable claim for a violation of due process if the circuit recognized a state-created danger theory. The plaintiffs rely heavily on an out-of-circuit opinion in which the Second Circuit held that a state-created danger theory gives rise to a substantive due process violation where the police conduct encouraged a private citizen to engage in domestic violence by fostering the belief that his intentionally violent behavior would not be confronted by arrest, punishment, or police interference. But, as the district court explained, this circuit does not recognize this theory, and so we decline to do so. So a parallel circuit has said that there might be liability if the police actually encourage the domestic violence person to engage in domestic violence. However, A, that is not the fact pattern here. The state doesn't seem to have done anything to encourage the person, so it's not applicable, at least as far as I can see. And B, it's not relevant anyway because it's not case law in the circuit and they're not going to adopt it. Okay, carrying on. Kurt starred The Purge, or something like that. Plaintiffs argue the district court erred in granting summary judgment in favor of the individual defendants based on discrimination for race, gender, socioeconomic background, and status as a domestic violence victim. In Shipp versus McMahon, this court adopted a coherent approach for courts to review equal protection claims pertaining to law enforcement practices. To sustain a gender-based equal protection challenge, the plaintiff must show the existence of a policy, practice, or custom to provide less protection to victims of domestic assault than to victims of other assault. One should take careful note here that if the policy is to protect no one, that is most definitely equal. So there's that. That discrimination against women was a motivating factor, and that the plaintiff was injured by the policy, custom, or practice. Cody Sam says, so they can't go after the cops because of case law. Can they go after the dispatcher? No. Negligent practices? No. No. They can't do any of those things. No one's liable. No one's liable for anything. No one's liable for anything. The police have no duty to protect you. The fact that they were negligent is irrelevant. The fact that they were careless is irrelevant. They have no duty to protect you. No one's liable. Welcome to case law. Yeah. So, in considering qualified immunity here, our analysis turns on the first prong of the qualified immunity inquiry. Have the plaintiffs raised a fact of dispute as to whether the defendants intentionally discriminated? And with respect to the claims based on gender and status as domestic violence victim, were the injuries incurred by an existing policy or practice? Seems like they should be charged? Why? It's not a criminal violation. Things are only criminal like when you take an affirmative action. There's almost no crime. In fact, there may be none. Well, that's not true. There are a few limited circumstances, but there's almost no crime where failure to do something is illegal. So, the police just failed to do stuff. It's not criminal. It's not a crime. It's not civilly wrong either. Yeah. However, on the second prong of the analysis, we find the plaintiffs have failed to raise a genuine dispute, a material fact, as to whether the discrimination against women was a motivating factor. So here the court is saying that you just made a blanket allegation and have failed to show any sort of discrimination on the basis of any of the protected classes. The fact they didn't do anything is just the fact they didn't do anything. You didn't show it was because of a protected reason. Plaintiffs make the same type of argument with respect to their claims that the officers responded to calls from similarly situated Caucasian women or calls from affluent neighborhoods more quickly. For example, plaintiff characterized an "I do not remember" or "I'm not sure" as an admission from the officers. Plaintiff constantly argues the fact that the dispute regarding individual defendants' intentional discrimination against Diana and Vicky exists because of evidence that individual defendants could recognize traits of Diana and Vicky from the call, and the district court made an improper credibility assessment in considering the record with respect to the assertion. So here they're trying to argue that you could tell that we were a particular race because of the way we talked on the phone, which I would incidentally argue is basically a prejudicial argument in and of itself, because you're saying that particular races talk particular ways. So that itself would be stereotyping, wouldn't it? But let's press on. We recognize that district courts consider the individual defendant's testimony that they did not know of Diana's, or where applicable, Vicky's race, or recognize the area in which she resided. But summary judgment requires a party asserting a fact that is generally disputed must be supported by citing to particular parts of material in the record, including depositions or documents, or showing the material cited do not establish the absence of a genuine dispute. Plaintiffs have failed to identify any evidence in the record disputing the fact that the individual defendants were not aware of their race or socioeconomic background. So yes, if you're going to prove discrimination on the basis of race, you actually have to prove discrimination on the basis of race, and they didn't do that. They didn't have enough evidence here to show it. Whether or not it's true, one could speculate, but there's not enough evidence to show it. So yeah, that's fair. I think that's it. Okay, let's end that. So that is the end of the case of Vicky Cook versus the city of Dallas. In this case, we learned once again the truth that the U.S. government or city government or state government has no affirmative duty to protect you. So for all the people who are gun control advocates out there who say, why don't you just call 911? This would be why we would tend to say that that might not work. There are several cases on point. Some of those cases were cited by the court, and there are many other cases that say the same thing. The police have no affirmative duty to protect any individual person, even if you have a restraining order, even if there's ongoing domestic violence. That the fact the police did nothing is legally irrelevant. And here they were unable to prove it was based on discrimination as opposed to just laziness or error. And so there is no recovery. This is not a shocking decision from the Court of Appeals. It's well in line with the precedent. And so we learned once again that the government has no duty to protect you. So that is the end of this case. Hello, Evil Tribble. Nice to have you here. Hello, Ill Propaganda. Nice to have you here. This decision is in absolutely no way surprising on any level whatsoever. So, yep. Tells you once again. All right, let's see what else we got. Okay. How many circuits are there? 13, I think. There's 11 numbered circuits and DC in the federal circuit, so there are 13 circuits. DC circuit hears appeals for the city of DC, and the federal circuit hears mainly patent appeals and also claims against the federal government. And other ones are regional. This is 11th circuit. Yes, this is an 11th circuit opinion. Let's see if I can find a map. Anytime, Google. Anytime will be fine. Okay. There you go. So you can see in 9th circuit is the west coast there. 10th is in the middle here. 8th, 7th, 6th. 5th is down here. 11th, Alabama, Georgia, Florida. 4th, west coast, east coast here. 3rd, 2nd, 1st. So yeah, there's your map. Puerto Rico is first. Puerto Rico's in the first. Blue. So they're first. And Alaska, Hawaii are in the 9th, as you can see from the color coding. Yeah, 9th is basically half the country. So yeah. And Guam and Northern Mariana Islands are all in the 9th. So Hawaii, Alaska, Guam, Northern Mariana Islands, and Puerto Rico's in the first with Maine. Well, so yeah. And then you have DC and federal. So DC hears cases that come from the city of DC, federal cases from DC. That's a lot of administrative cases in particular, a lot of agencies. So DC circuit's normally considered the most important circuit because they hear a lot of administrative cases. And so, yeah, they get a lot of attention. And federal circuit does patent appeals and claims against the federal government. So, yep, there's your map. There's your 11 circuits. Exciting. DC is the fastest past the SCOTUS. I don't know if that's necessarily true. I mean, they hear a lot of really important stuff because they hear a lot of stuff dealing with administrative agencies. And so it's probably more likely than any other circuit to, like, say the government doesn't have power. And that usually gives a pretty easy appeal. But yeah, they just hear a lot of really sensitive and important stuff. So I don't know if it's the most likely to see an appeal. I don't know if there's statistics on that. So yeah, but there's your map. And lately, yes, the Court of Appeals does love to bash the federal circuit, and they also love to bash the 6th Circuit on habeas issues, habeas corpus issues. They love to bash the 6th Circuit on habeas corpus. Yeah, the 9th used to be the whipping ground, but they're not as much anymore. It's the 6th Circuit and Federal Circuit these days. They're getting beaten up by the Supreme Court all the time. So, kind of cool, huh? Now you know. Now you know. Okay. Is there any particular reason why they aren't standardized? No, there's not. The way that they're drawn is because Congress set it up that way. It's no more complicated than Congress passed a law and said these states are in these circuits. Why Congress made those choices, one could only guess. So there have been many, many, many attempts to try to redraw the Ninth Circuit because it's so huge, but they can never get it done. Anyways. Okay. Hello, everyone, and welcome to Uncivil Law. For today's case, we have Cambridge Christian School versus the Florida High School Athletic Association. In this case, two Christian schools were playing a football game. The game, however, was administered by the Florida High School Athletic Association, which is a government entity. The two Christian schools wanted to have a prayer over the state. The two Christian schools wanted to have a prayer over the broadcast system as part of the game. The Florida High School Athletic Association, however, said that this would be improper state action as it relates to establishment of religion. The Court of Appeals thinks that there's not enough factual record to decide this, and so I thought it would be a really interesting case to show some interaction between private action and state action when it relates to religious issues. So let's read this case and see what happened. At the end of the 2015 high school football season, Cambridge Christian School and University Christian School faced off in the football game. The two schools, both Christian institutions, asked the institution that was doing it for permission to conduct a joint prayer. The FHSAA denied the request, citing the separation of church and state. The main reason to split the Ninth Circuit is because it's so huge that even when they sit en banc, they don't sit en banc. So, like, when you sit en banc, all the members of the court are supposed to sit. But the Court of Appeals for Ninth Circuit has 23 members. So, they only have half those sit. So, that's one of the reasons. It's just because it's so big that, like, they can't, they can't ever, like, do what they're supposed to do. So, Cambridge Christian bought this law school in federal district court, raising a variety of claims, primarily free speech and free exercise. The trial court dismissed the entirety of the complaint for failure to state a claim. For starters, it concluded on the free speech claims that all the speech over the loudspeaker was governmental speech, and therefore the school enjoyed no expressive freedom in the medium. In the alternative, the court determined the loudspeaker was a non-public forum and that Cambridge Christian was not entitled to access. As for the free speech clause, the court held the school's free exercise rights had not been implicated when the institution denied access because the teams were still allowed to pray at the center of the football field, albeit without the aid of the loudspeaker. As we see it, the district court was too quick to dismiss the claims. There are too many open factual questions for us to say with confidence the allegations cannot be proved as a matter of law. The question is whether all speech over the microphone was governmental speech, is heavily fact-intensive one that looks at the history of the government's use of the medium. For communicative purposes, the implication of government endorsement over the messages, and the degree of government control over the message. Here, the history factor weighs against the government speech, and the control factor is intermediate, so based on this limited record, we find it plausible that the multitude of messages delivered out of the loudspeaker should be viewed as private and not governmental speech. And while we agree with the district court that the loudspeaker was a non-public forum, we conclude that Cambridge Christian has plausibly alleged it was arbitrarily and haphazardly denied to the forum. So a couple things here. The first question is whether or not this is governmental speech or private speech. If it's governmental speech, then government gets the right to control its own message, and the government is barred from engaging in religious shows of proselytization, for example. Here, the court is saying that's unclear on the record because the medium seems to have been used for both kinds of speech, and so it's unclear that it could be viewed as governmental speech. And it's also saying that there's unclear on the record as opposed to the discrimination, so it's sending it back for further findings. Cambridge Christian football team plays in Division 2A, which is supervised and regulated by Florida's High School Athletic Association. The association is the governing nonprofit organization of high school athletics. It is so designated by the Florida legislature in 1997, and because of the statutory delegation of authority, is a state actor. It includes over 800 member high schools throughout Florida, many of which are private and religious in nature. In 3 earlier rounds of the playoff, Cambridge Christian was the home team and hosted the games at Skyway Park, a public facility in Tampa owned by the county. Before each of these games, Cambridge Christian apparently was allowed to pray at a loudspeaker at the park. During a December 1st, 2015 conference call 3 days before the game, the representatives of Cambridge Christian and the University Christian, that is both teams, asked to use the loudspeaker at the stadium to lead attendees in a pregame prayer. University explained it had been allowed by the association to use the loudspeaker prior to a 2012 championship game against a different Christian school. The association responded later that same day and said that they were unable to comply with their request. He explained the facility was a public facility, that they were a state actor, and therefore it could not permit or grant a request for a pregame prayer. Before and after the game, the PA system was used by the association's public address announcer to deliver a variety of messages, including advertisements, commentary, and other communications. At halftime, each team was given 7 minutes for its cheerleading squad to perform. During this time, Cambridge Christian said it was permitted by the association to take control of the loudspeaker, in which cheerleading coach used to play music from her smartphone. Putting aside the obvious copyright issues, the fact that advertisements were relayed during this and other non-speech action occurred on the system does seem to undercut the fact that it's purely a governmental speech medium. So there was a mix of both governmental and private use of this medium, and so that does undercut that argument. The association explained that prayer before football games have been richly debated and decided in the courts of the United States. He referenced, unmistakably but not by name, the Supreme Court's decision in Santa Fe Independent School District versus Doe, which involves exactly this issue, prayer over a loudspeaker during a football game, as being directly on point. It is directly on point, and established precedent preventing the association from granting the request. Doing so, the association explained, would mean the state actor was endorsing or promoting a religion. The email also argued that no one had been prevented from praying. The fact of the matter is both schools involved had prayer on the field both before and after the game. The issue is never whether the prayer could be conducted. The issue was and is that the association, the governmental association, which is deemed to be a state actor, cannot endorse or promote religion. The issue of prayer in and of itself was not denied to anyone in the team or anyone in the stadium. It's simply not legal, permitted under the circumstances which were requested. The district court began its analysis by addressing Cambridge Christian's free speech claims. It concluded, based on a review of the complaint, that all communication over the loudspeaker during the championship was governmental speech, thereby eliminating all the free speech claims. But in the alternative, that even if some of the speech over the loudspeaker was private speech, it occurred in a non-public forum where the exclusion of the requested prayer amounted to a permissible content-based regulation. Perhaps of greatest significance, the parties disagree about how we ought to classify and analyze Cambridge Christian's claim under the Free Speech Clause. The association claims that all the speech over the loudspeaker was governmental speech and thus not subject to the provisions of the First Amendment at all. The association argues in the alternative that even if the prayer would have been private speech, the public address system was a non-public forum, which they denied access to. Cambridge Christian argues, however, the public address system was a limited public forum, but the forum analysis is besides the point because the association discriminated against its speech on the basis of its religious viewpoint, which would have been impermissible even in the non-public forum. So we see the two arguments. The government is arguing it's governmental speech and it's permitted, and they're arguing that no, they based it specifically on religious, which they're not allowed to do, and so therefore it was religious-based discrimination. Okay. The district court reached two basic, albeit independent, conclusions. First, it held that all the communications over the loudspeaker was governmental speech. Alternatively, the trial court concluded that even if the public address system was some type of forum for private speech, it was a non-public forum at best, and the restriction was lawful. We, the Court of Appeals, disagree with both conclusions. As we see it, there are simply too many key facts left undetermined at this preliminary stage. It is by now clear that under the First Amendment that if all the speech over the loudspeaker was governmental speech, the case could not proceed under the Free Speech Clause. Taking the facts in the light most favorable to Cambridge Christian, we find a history of private speech, and also that allegations regarding control of speech delivered over the address system paint an unclear picture. Because one of the three key factors towards finding that at least some private speech was disseminated over the address system and the control factor is mixed, we reverse the district court's threshold conclusions that the public address system was used to convey only governmental speech, along with its dismissal of the free speech claims and remand for further exploration of the relevant facts. So the Court of Appeal is, of course, not finding any facts. They're simply saying that the factual record is incomplete. You need to figure out whether this is a governmental speech or it's not. And there seems to be evidence on the factual record that there's some non-governmental speech. So you need to analyze that along with other stuff and figure out whether this is a governmental forum, a private forum, or some sort of mix between the two. And saying, based on the fact we have some evidence here, you dismissed it too fast before there could be a factual finding. And I tend to agree with that. There does seem to be an underdearth of it because it was dismissed on summary judgment, right? So there was no discovery and no trial. So there doesn't seem to be enough evidence to reach this kind of conclusion. And one of the evidence that's on record seems to undercut the conclusion. So this seems to be appropriate for that reason. The first factor, history, asks us to decide whether the type of speech under scrutiny has traditionally communicated messages on behalf of the government. Here, the district court concluded the history factor weighed against finding the speech was governmental speech. We agree because allegations in the complaint strongly suggest the state has allowed dissemination of prayer over the system in the past. Thus, we are satisfied that Cambridge Christian has alleged enough for us to say history plausibly weighs in favor of characterizing the speech over the loudspeaker as being, at least in part, private. The second of the factors, endorsement, asks us whether the kind of speech at issue is often closely identified with the public mind with the government, or somewhat differently, whether observers reasonably believe the government has endorsed the message. While speech disseminated over a loudspeaker at an event is plainly more transient than any of the comparators, for example, states, statues, license plates, or banners, it is tied to the government spatially in the same way banners were tied to the schools and monuments were tied to the city because it occurs at a government-organized event. Just as we assume that owners of property do not generally put up banners or monuments that convey messages with which they disagree, so too we can safely assume the organizers of the sporting event, a league, a home team, or in this case the association, generally would not allow the public address system to be used to convey messages they did not want to be associated with. Cody Sam says, I'm confused by the conclusion. How does it happen before and make it okay? Couldn't it mean it's erroneously occurred in the past? Sure, it could mean that's erroneously occurred in the past, but it's still something you have to factually analyze because the question is basically the arbitrary and capricious nature of it. The government can't act arbitrarily and capriciously. It can allow it sometimes, not other times. So yes, it could be that they made the mistake before and they're correcting that mistake, but again, that is not clear on the record because there's not been any testimony to that fact. No one testified that we realized that we made a mistake and so we decided a new policy going forward. And so if that's the case, then that's the case, but we haven't developed the factual record to know whether it's arbitrary or whether it's based on a correction of the past. Excellent question, though. The types of message conveyed over the loudspeaker also suggest observers would believe government endorsed the message conveyed over the loudspeaker. Advertisements over the public address system might be relevant to any analysis of the endorsement factor, but at this point we don't know much about them. All the complaint tells us is the messages were delivered by the announcer. So exactly how they were labeled and how they were described might be relevant. This is, again, going to a factual question that's not well developed. Cambridge Christian argues, nevertheless, the endorsement factor weighs strongly in its favor, but that argument is unconvincing. It points to our statement that views do not become state views merely because they're being uttered at a state event on a state platform. But we've said that in an establishment clause case, not a free speech case, and reference to government speech overall, not an analysis of the endorsement factor. It's surely right that views don't become state merely because they're uttered on a state platform, but being uttered on a state platform certainly helps. Yeah. Finally, the control factor asks whether the relevant government unit maintains direct control over the messages conveyed. The association controlled physical access to the microphone, but notably, whether it controlled content of the speech that went out over the loudspeaker is far from established. Lynch says, so what about if it was announced that this was a message from the school only? Yeah, maybe that would be a turn of difference. It could be. That could be enough. Maybe. Yeah. Thus, we find nothing in the administrative procedures or participant manual to indicate whether the association reserved any right to reject a song or musical choice, or participating schools could not play songs with, for example, explicitly religious or political messages. We also don't know what it means to take control of the loudspeaker and whether this entailed access to the microphone. Given the lack of facts as pled, we simply do not know if any limits were in place. So here they're referring to the musical selection that was used during the halftime cheerleading performance. So it's not clear if the government made any sort of decisions on what sort of songs to allow or what sort of routines to allow. And so if a person chose a religiously themed song, would that be allowed to be displayed? And, we don't know. So that goes to, again, to a factual issue that needs to be developed. Well, yeah, they did. Higgins, they didn't fully control the loudspeaker. That's one of the points. During the halftime show, apparently one of the people was allowed to hold up their smartphone and play music from their smartphone. So there was, at that moment, apparently a lack of control. So it's not a uniform control aspect. So, The long and short of it is we simply do not have enough information to say with any confidence that if everything in the complaint is true, speech disseminated over the public address system was and would not have been governmental speech as a matter of law. The history of prayer at past games, as alleged in the complaint, tilts the first factor against finding speech presented over the loudspeaker was governmental speech, but the implicit endorsement of messages carried out over the loudspeaker at a state event cuts the other way. If some or all the speech conducted over the loudspeaker at the 2015 championship was not governmental speech, that necessarily means at least some of it was private. Our courts have employed a forum-based approach for assessing restrictions the government seeks to place on the use of its property. This requires us to consider what kind of forum has been created, what restriction on access has been enforced, and whether the restriction was constitutionally permissible. So here it's saying that if there is some ability for the private people to communicate on this forum, that there are standards in terms of what kind of forum it is that the government has to follow based on what kind of opening it has given. The first step in the analysis is to discern the nature of the forum. The association plainly did not create a traditional forum. Traditional forums are things like park streets. They are like long established things. It would be hard to create a traditional forum, but they're long established things. It's obviously not traditional in that sense. We can also say with great confidence that we're not looking at a designated public forum. Designated public forums have to be done with some intentionality, and that's obviously not the case here. They didn't say, yes, this is a public forum, so that's not the present issue. Two options thus remain, what's called a limited public forum or a non-public forum. A limited public forum exists where the government has reserved the forum for certain groups or discussions of certain topics. Finally, a non-public forum is a governmental space that is not by tradition or designation a forum for public communication. A space where the state is acting only as a proprietor managing its internal operations falls into this category. Examples include polling places, mailboxes of public school teachers, terminals in airports, and military bases. Cambridge Christian has not plausibly alleged the association created anything more than a non-public forum. A state actor does not create a public forum, limited or otherwise, by inaction or by permitting limited discourse, but only by intentionally opening a non-traditional forum for public discourse. The extent to which the forum is open in various speakers is relevant for what it suggests. Speech in a non-public forum can be restricted in order to preserve the forum for its intended purposes, communicative or otherwise, as long as the regulation on speech is reasonable and not an effort to suppress expression merely because public officials oppose the speaker's view. The government has much more flexibility to craft rules limiting speech in a non-public forum than in any other kind of forum. But it's equally clear that non-forum status does not mean the government can restrict it in whatever way it likes. Thus, it remains true that even in the non-public forum, any barrier to access must be viewpoint neutral and cannot be exercised in an arbitrary and haphazard manner. Because there is little reason to think from the complaint and the limited record that the association would have allowed prayer from one religious sect but not another, or would have allowed some solemnizing messages but would not allow other messages, we think the restriction amounts to a content rather than viewpoint-based discrimination. The email from the association concluded that since the association was a state actor, according to Florida courts as designated by the statute, the organization could not have granted Cambridge Christian's request without running afoul of Santa Fe Independent School District versus Doe, where the Supreme Court held that a public schools district's policy of permitting student-led, student-initiated pairs over a loud system at the start of football games violated the Establishment Clause. Cambridge Christian argues this request was denied because of the religious perspective of its speech, which makes it viewpoint discrimination, but we disagree. The complaint does not allege, for instance, that Christian prayers were prohibited, but Jewish or Muslim prayers which would have been allowed, which would have presented viewpoint-based discrimination. Having concluded the complaint plausibly alleged the forum was likely a non-public one and the FHS and the association's restriction was likely content-based, the final step in our analysis is to examine the restriction for reasonableness. The Supreme Court has made it clear that even in the non-public forum, the government must avoid haphazard and arbitrary enforcement of speech restrictions in order for them to be upheld as reasonable. The complaint has plausibly alleged that the association's prohibition on prayer at the 2015 game had a substantial defect. The restriction was arbitrary and haphazardly applied by the state. So here they're arguing that it was arbitrary and capricious, arguing that the government acted without rhyme or reason, and the government's not allowed to do that. Notably, Cambridge Christian has alleged that two participating teams, University Christian and Dade Christian School, were allowed to pray before the 2012 game administered by the association, and that it prayed over the loudspeaker during the first 3 rounds of the 2015 playoffs before the games conducted under the auspices of the association. So other teams were permitted, they were permitted under various times, but they're not permitted now, and nothing really has factually changed. So that does tend to suggest arbitrary and capricious. Permitting certain speech on Monday, Tuesday, Wednesday, and Thursday, and barring precisely the same message on Friday without any credible explanation of what may have changed is the essence of arbitrary, capricious, and haphazard, and therefore unreasonable decision-making. The school's message does not appear to be naturally incompatible with the purposes of the forum. We know that prayers were delivered on 4 prior occasions, presumably without incident. The undefined message may have been presented by the schools, and the schools had considerable leeway in presenting their halftime shows, and at this preliminary stage of litigation, we lack any record of evidence to explain the restriction. The explanation that it wanted to comply with the Establishment Clause and the Supreme Court's decision in Santa Fe might have been reasonable in a vacuum, but it does not explain why the restriction was enforced in an inconsistent manner. So the association is saying, look, we developed this rule because the Supreme Court required us to in this particular case. And that seems perfectly reasonable, but it's not reasonable on the record why it endorsed it some places and not other places. It may be the association simply made a mistake, but because we don't have any factual record or testimony to that fact, we don't know what the basis was. So we don't have a well-developed record to know what the thinking of the government was in terms of its enforcement of the statute. We do not foreclose that a court may later conclude on a fuller record that any message delivered over the loudspeaker was governmental speech or the restriction was reasonable. The only question we face today is whether it is said enough to make it a plausible case, not whether it will probably prevail. Personally, I think once the record is more fully developed, they will not prevail, but they're entitled to their hearing and day in court just like everyone else. I believe that's it. Yep. Okay, that was cool. When it comes to the government lint, yeah, lack of consistency is a problem. You know, it's not necessarily arbitrary and capricious, but it does suggest it, right? If it's without rhyme or reason or obviousness, it's like, well, why are you doing this? It's like, yeah, so. So that is the end of the case of Cambridge Christian School versus Florida High School Athletic Association. In this case, we learned that 2 Christian schools want to give a prayer before a game. There is a case on point from the U.S. Supreme Court that says this is improper. However, in prior instances, they have been allowed to pray, including at prior games during this year. The association that administers this, which is a public association run by the government, apparently allowed it in prior instances and did not hear. It's unclear why, however, the government acted the way it did. The government is not allowed to act arbitrarily. Perhaps the government simply made a mistake, but that is not on the record before us. So they went back to trial to figure out what is going on, to figure out what happened, and to figure out if there's discrimination in terms of unequal application of the law. So we will see what happens next once the record is more fully developed. Aren't there cases where government can act arbitrarily capriciously, such as anything political or otherwise? Not in terms of enforcement, not in terms of like executive action or judicial action. Can the legislator act arbitrarily and capriciously? I'm not even 100% sure the legislature can act arbitrarily and capriciously. It can be pretty thin, but there is like the minimal standard usually is rational basis. So like you can treat things pretty differently for pretty thin reasons, but you usually have to have a reason that, you know, passes the laugh test. So I'm not even sure the legislature can act arbitrarily and capriciously, and the executive certainly can't. So I would say probably no, there's no instances where the government can act arbitrarily and capriciously. If it's rational basis, you don't need a lot though. So it can be pretty thin. Matthew Lego says, what about the DA deciding whether to charge a case? Isn't that allowed? I'm glad you asked. There actually is issues with this. There actually can bring a case of selective prosecution. So while for the most part, the DA can choose who to prosecute and who not to prosecute, if you can show like the DA is targeting specifically you because it's you and not anyone else, you can actually like kill the case because it's selective prosecution. So even in the enforcement of like what cases to bring and what not, you can't be arbitrary to the point of going after a particular person just because you don't like them in particular. So even in that case, you have to show some rationale for why you're doing what you're doing. So, but good question. Yeah. Rational basis is pretty thin though. You don't need a whole hell of a lot. Are there any situations where government doesn't win rational basis? Yes. I don't know that I can think of any off the top of my head where they didn't on rational basis review. But it definitely has happened. But I don't know if I can think of any examples off the top of my head. You know, it doesn't happen very often, but there's definitely been cases where it's happened. You know, although the Supreme Court didn't go this way, if I were on the Supreme Court, I would have ruled the gay marriage ban was unconstitutional because it was not rational basis. So I would have struck that down for not even passing rational basis review. Supreme Court didn't decide it that way, but if I had, that's what I would have decided that. So that would be an example where I would say you wouldn't make rational basis review. But there are definitely some examples. Yeah. Okay, let's move on. Okay. This is an interesting case. I don't know that the Supreme Court told Trump to lie better. That's not quite what they said, but your point is noted. For today's case, we are Hello everyone and welcome to Uncivil Law. For today's case, we are reviewing a district court's decision in the case of Ghassan al-Assad versus the Department of Homeland Security. In this case, the district court found that the federal government went too far in conducting a search as part of an immigration customs enforcement. Here, customs was searching cell phones by going into the phones and getting data from the phones, and the court said this was actually improper. This is a very unexpected decision, actually. The United States government enjoys quite a lot of leeway at border, so it's quite unusual for a court to strike down a search as being improper. So we're going to read the reasoning of the district court as it relates to this and see what happened. Plaintiffs, 10 U.S. citizens and 1 permanent resident, alleged the defendant's conduct searching the plaintiff's electronic devices at port of entry to the United States, and in some instances confiscating the electronic devices being searched pursuant to policies violates the Fourth Amendment. Although governmental interests are paramount at the border, where such non-cursory searches, even basic searches as broadly defined under policies, as well as advanced searches, amount to non-routine searches, they require reasonable suspicion the devices contain contraband. It's pretty unusual for a court to say that reasonable suspicion is required for a border search. Normally, reasonable suspicion is not required for a border search. They're checking for contraband. They can just check stuff. So for them to say that you do need reasonable suspicion is pretty unusual for a court. The material facts concerning the searches of the electronic devices and the policies pursuant to the statutes are undisputed. What contraband could be on file on a phone? Lots of stuff. Anything that's digital, that's contraband. Governmental secrets, classified information, certain kinds of child pornography. Yeah, you can definitely have classified. You can definitely have things on there that you're not supposed to. I was under the impression merely crossing a border was reasonably suspicious. It's just basically we can do it because we feel like it, but yeah. Illegally downfill the movie, sure. Yeah. The two agencies with primary responsibility for border searches are Border Protection and ICE. Both agencies have written policies. In 2018, Border Patrol updated its policy to distinguish between two types of searches, basic and advanced, and to require reasonable suspicion or national security concern for an advanced, but no showing of cause for the basic search. Under this policy, an advanced search is defined as any search in which the officer connects external equipment through wired or wireless connection to an electronic device, not merely to gain access to the device, but to review, copy, and analyze its contents. The parameters of an advanced search are clearer given this definition than that adopted for the basic search, which is merely defined as any border search that is not an advanced search. Both Border Patrol and ICE use the same definitions. Lynn, again, I would suggest that even in that scenario, it's not arbitrary and capricious. Usually there's some rule. It can be a very like thin rule, but it can be a rule. Like we're going to check every fifth person, or because you think that they're like acting suspicious or whatever. There's usually some rationale. So like, it's not quite arbitrary and capricious. There's some reason behind it. Each of the 11 plaintiffs have and even if it is arbitrary and capricious, the government power at the border is at its zenith. So it may be like the place where the exception tests the rule, because governmental power at the border is pretty high. So it may be an exception to the rule. Each of the 11 plaintiffs has had their electronic devices searched at the border. Some of the searches were at border crossings, although most were at U.S. airports. The search of electronic devices included laptop computers. 5 of the plaintiffs had their electronic devices searched more than once. 2 of the plaintiffs had their devices searched during subsequent filings. A guy named Merchant is the founder and editor of a media website and has had her phone searched during multiple times despite her concerns about them seeing pictures of her without her headscarf on. Merchant observed the Border Patrol viewing communications between her and her lawyer. Dupin's phone contained information from his work as a journalist, while Bikanar's phone was a work phone officially owned by NASA. It is undisputed that information gleaned by Border or ICE during certain of these border searches have been retained. So they've retained the information. Information observed by the agents during the search has been retained. Reports containing such information note not just the fact that they conducted the search, but in some instances, observations and characterization of the information contained therein. The court denied the defendant's motion to dismiss, concluding the plaintiffs had set forth a plausible Fourth Amendment case. In ruling on the defendant's motion to dismiss, the court ruled the plaintiff had demonstrated standing by plausibly alleging an injury in fact traceable to defendant's alleged conduct that was likely to be redressed by a favored decision by the court. Moreover, the record regarding a substantial risk of future harm has been borne out. The current records show that agents have potentiality to access information on the past searches, and such information may be used to be informed future searches. I don't know why I'm speaking like I'm an incompetent today. I swear, I'm not this stupid. I'm just talking all over myself. I hope these recordings are going to be useful. Damn. The recent additional search of Ali Bad's device on July 6, 2019 furthers plaintiff's argument as to the risk of future harm. Ali Bad had been subject to a border search in 2017. When he declined to provide the password to his locked phone, Border Patrol seized it to conduct an examination. Ali Bad arrived at Toronto Airport for a flight to Dallas, traveling with a smartphone and laptop. The officer searched both devices. that such search of the electronic devices continues for plaintiff in the midst of their ongoing legal challenge to the same serves as further indication that this will continue. Knight said, been meaning to post this for a few months. Where's the rest of Todd Valentine's videos? You know, every time I try to record videos on that, I am just never happy with my recordings. I have tried like 4 or 5 times to record more stuff. And every time I try to record more stuff, I'm just not happy with it. And so it's like, I just have such trouble finding something that I like. So, you know, but, you know, I really should finish the story. So one of these days, I really have got to try. So I will give it another shot. I'm sorry. You know, I know that a lot of you guys have been waiting for me to finish that. And so, you know, it's just an issue of me, like, being able to finish the story. But it's just that I've tried and I've never been happy with what I record. It's a story I guess I want to get right. So. The last time I tried to record it, I didn't redact it in advance. And there was so much personal information in there with like personal addresses and stuff for like all these people, as like, you know, I couldn't go forward. It's like, you do not need to know like personal addresses of like everyone involved and like social security numbers and shit. It's like, I do not need to reveal this information to you. Which means I have to go through and redact everything, which is a pain in the ass. Anyways. This likelihood of future harm of plaintiffs being subjected to searches of their electronic devices is not undermined, as argued by the defendants, by the fact the overall percentage of such searches is low. You didn't have to delete your message tonight. It was perfectly fine message. I didn't mind the message. I mean, it's a reasonable question. And, you know, it's a reasonable ask. So you didn't have to delete your messages for me. Specifically, defendant pointed out the stipulated facts here that one of the hundreds of millions of international travelers processed by border, for one example, approximately 0.007% had their electronic devices searched. Yeah. Defendant also challenged plaintiff's standing to seek expungement. As plaintiff framed it now, they seek expungent information defendants concede they retain. Here now, plaintiffs seek to expunge information gathered from their electronic devices and any copies made of their electronic devices, social media, and device passwords. I don't mind questions. I don't mind questions. You know, it's just as long as they're asked nicely and respectful. And that was asked very respectfully. Like, you know, I posted videos and never finished it. I'm like, why? Well, because every time I tried it, it doesn't work. Not that I'm super thrilled with these videos that I'm making. Like, I'm of course such a critic of my own work, and like I watch back my own videos. Perhaps that's not the greatest action, but I have to watch them like at least once to edit them. And then I watch them when I post it to just like see how it sounds and like learn something. I'm just not happy with like my own performance. It's just, I watch other people and they're so much better. Like, you know, watch Leonard or watch Viva and I'm like, they're so much better than me. And so the Todd Valentine story is a story I really care about. And so like every time I record it, I just watch it and I'm like, this sucks. And so like, I'm just a critic of myself. I want to be better than I am. I want to be the very best that no one ever was. Tetchup is my true quest. The catch-up is by cause Pokemon. Yeah. So that's why I haven't recorded Todd Valentine videos, because I want to get it right. I care about the story and I hate my work. Brendan Bush says, I'm going to be honest. I find your videos to be much more helpful than Leonard's, at least from a perspective of someone who's legitimately curious about learning. Well, thank you. I will take any compliment I can get. I like to explain things. I want this to be a teaching tool. Like the vision is that this should be accessible to anyone with a college education. You know, it shouldn't require any particular special knowledge of law. And so I have to explain stuff and obviously offer my own opinions and perspectives, which I think are helpful. And if not, you get them anyway. And yeah. Everyone that edits themselves hates themselves. And editing is such a pain in the ass. It takes such a long ass time. Being a piece of shit. Let's see. I'm not looking forward to editing this video, I'm telling you right now. Border Patrol and ICE retain the substance of data seized from both basic and advanced searches of electronic devices as an agent description of the same in the databases. ICE's policy permits retention of the information from electronic devices that is relevant to immigration, customs, and other law enforcement matters, and allows sharing of retained information with other law enforcement agencies. Plaintiffs challenge both the constitutionality of their search and the claim that Border and ICE allow for border searches of electronic devices without warrant, even as these policies still require no showing and now reasonable suspicion for the advanced searches. I was pointing this out when I was doing the lawyer jokes about like the crippling balance of ego and depression. It's like I that rings true to me, man. It's like I have ego and I also think I'm totally worthless. It's like it's the wonderful mix of thinking that you're the greatest thing ever in the history of time and you're smarter than like the entire Supreme Court and you're the greatest thing that ever was, coupled with utter fear that you are completely incompetent and, you know, you hate yourself and everything you've ever done in your life. It's super fun being in my head, let me tell you. The border search exception, grounded in the recognized right of the sovereign to control, subject to substantive limitations imposed by the Constitution on who and what may enter the country, is an exception to the general Fourth Amendment rule. As previously observed by this court, the border search serves the nation's paramount interest in protecting its territorial integrity. The rationale supporting the border search exception are the sovereign's interest in protecting the integrity of the border by regulating the collection of duties and preventing the introduction of contraband into this country. Travelers may be stopped because of national self-protection reasonably required, one entering the country to identify himself as entitled to come in and his belonging and effects to one that may be lawfully brought in. Supreme Court has characterized customs officials' role at the border as greater than that of investigative law enforcement, explaining that customs officers are also charged with protecting this nation from entrants who may bring anything harmful into this country, whether that be communicable diseases, narcotics, or explosives. Absent more precise guidance from the founding era, we generally determine whether to exempt a given type of search exemption from the warrant requirement by assessing, on the one hand, the degree to which it intrudes upon an individual's privacy, and on the other, the degree to which it is needed for the promotion of a legitimate interest. That is, the border exception is not limitless. It must still be reasonable and subject to the same balancing level of intrusion upon an individual's privacy and necessity for the promotion of a legitimate governmental interest. I am sadly forced to disagree with the court as much as I really want to, because I think the amount of searches that they do are completely over the top. But I don't think reasonableness really applies at the border. The border is a place where the government has unbelievable amounts of power. Like normal constitutional guidelines completely break down. First Amendment guidelines break down at the border. It's like it's a place where things are at their zenith. So I'm not sure any reasonableness is really required for like these kinds of searches. So I don't think the court is right here. I think the court's going to get overturned on appeal. I really do. It's very sad, but true, I think. You don't always get to reach the decisions you want to reach, guys. It's a sad fact of law. What the border search exception recognizes, rather than a limitless ability to conduct searches in connection with international travel, is that individuals have a reduced expectation of privacy at the border when the government's interest in preventing entry of unwanted persons and effects is at its zenith. $10 from Midnight Rose to Uncle Blackleaf for his wonderful videos to boost his self-esteem and in sympathy with the feelings he expressed, a feeling both good and horrible about himself. Well, thank you very much for the $10. It does help me and helps my channel grow. You know, I use the revenue that I get from this to help buy ads to promote the channel. So I just use it to promote the channel so it'll help grow. So thank you for the money. I appreciate it. You know, it's funny because like one of those, like not this past time, but the time before when I was doing Scottish React, and I was doing it on Kansas v. Glover. And I was feeling pretty good about myself because like I'm feeling like I'm smarter than 7 out of the 9 Supreme Court justices that day, which that's a lot of hubris. But I'm like, I'm smarter than 7 out of 9 of these guys. And now today it's like, I don't work for the... But thank you for the support. It really means a lot. I thank you for it. Thanks for the validation. Defendants have a paramount interest in maintaining territorial integrity at the border. They define such to include responsibility to ensure interdiction of persons and goods illegally entering or exiting the United States, facilitate and expedite the flow of legitimate travelers and trade, administer the enforcement of customs and trade laws, detect, respond to, and interdict terrorists, drug smugglers and traffickers, human smugglers and traffickers, and other persons who may undermine the security of the United States, and enforce the immigration laws. Defendant further cites interests served by the border exception as helping to promote national security, prevent entry of criminals, inadmissible aliens, and contraband, facilitate lawful travel and trade. As to contraband, it is the interdiction of contraband, not evidence of contraband, that is paramount concern at the border, not evidence of contraband that might help future investigations. I don't know that I can agree with that conclusion. I mean, obviously search serves both purposes. You know, the purpose of Border Patrol is to seize things that shouldn't be here, but to suggest that they shouldn't or can't use those things as part of an investigation or to like direct their future activities makes no logical sense. It's like, obviously the things that come in are going to like provide them information that might lead to future investigations, might lead to future law enforcement investigations, might lead to future activities from customs themselves. So yes, their immediate objective is to seize the thing, but to suggest that that can't be used for further law enforcement purposes doesn't follow to my mind. Cody says, I don't understand why search electronic devices. Even deleting the data or seizing it doesn't ensure that that doesn't have another copy. Yeah, but the information it might in and of itself be illegal and illegal in a very big way, which obviously like not only can you destroy the information, but you can criminally prosecute them for whatever. So, you know, if you're searching their phone at the border and find child porn or find, you know, classified secrets or something, they're going to delete it. And they're also going to have many, many questions for you. So, I mean, that serves multiple purposes. And just because you can't get everything doesn't mean you shouldn't try to get something, right? So, I mean, just because we seized this 4.9 kilograms of cocaine, there's other kilograms of cocaine, so we shouldn't try. I mean, you know, that's kind of, yeah. When applying exceptions to the warrant requirement, courts must determine whether the search at issue is within the scope of the exception, whether the search furthers the underlying purpose of the exception, and whether the search, even if it's within the scope of the exception, intrudes upon competing privacy interest. Stopping an insect or smuggler would be a compelling reason. Yeah, particularly for like insects. I mean, we don't have to like go very far to point out examples of wildlife making it into places where they don't belong and it not going well. So yes, seizing flora and fauna is well within the scope of Border Patrol's interests, yes. The record recites searches of electronic devices at the border have successfully uncovered threats to national security, information pertaining to terrorism, illegal activities, contraband, and inadmissibility of people and things without explaining the frequency and nature of it. As to contraband, there are limits to the contraband that may be stored on digital devices. The form of such contraband, as identified by defendants, can include child pornography, classified information, and counterfeit media, even as such devices may also contain evidence of the same. The record of prevalence of such digital contraband encountered at the border remains unclear. Given the dirt, all you're doing is searching for incompetent criminals. Well, man, I mean, a surprising amount of time, criminals are just completely incompetent. I mean, like the amount of times like they are just idiots is like it would shock you. It's like any reasonable person wouldn't do this, but criminals get caught all the time from being just outright stupid. So you shouldn't underestimate the probability of the criminal just being completely stupid. It happens all the time, man. It happens all the time. Given the dearth of information of the prevalence of digital contraband entering the United States at the border, the court cannot require showing of some cause to search would be an obvious deterrent. The Supreme Court has described the border search exception as applying to routine inspections and searches of individuals or conveyance seeking to cross the border. Routine searches of persons and effects are not subject to any requirement of reasonable suspicion, probable cause, or warrant. This is what I was saying earlier. I mean, the idea of like any need of reasonable suspicion at all for any sort of like routine search is just not applicable at the border. The government has all kinds of power at the border. So, you know, that's completely right. Non-routine searches, by contrast, require reasonable suspicion. The distinction between routine and non-routine does not turn upon the frequency or the label, but the invasiveness. So let's watch now as the district court tries to desperately cram this into the non-routine category. Let's see how that goes. The ICE and Border Patrol policies cover the gamut of electronic devices. The policy defines an electronic device as any item which may contain information, computers, disks, drives, tapes, mobile phones, and other communication devices, cameras, music players, and any other digital device. Smartphones and laptops, devices that the plaintiffs were carrying, can contain information such as photographs, contacts, emails, text messages, as well as information such as prescriptions, employment information, travel history, and internet browsing history. Here, information on the devices when the devices were searched include attorney-client communications, pictures of the plaintiff, and information on journalism work. In the Supreme Court case of Riley, the court analyzed the applicability of the search incident to arrest exception to a search of arrestee's cell phone and held that officers must secure a warrant before conducting a search. So that was a pretty big U.S. Supreme Court case, I think from 2 terms ago, where they held that when you conduct a search of a cell phone pursuant to a routine arrest, in order to like actually get into the cell phone and look at the contents of the cell phone, you need to get a search warrant. That's not typically true in most cases. It was a pretty big exception the day the Supreme Court made that decision to say that, you know, because cell phones contain so much information, you need a warrant requirement. The problem is that in Riley, it was a search. The problem was that in Riley, it was a search pursuant to an arrest. Here, it's a search pursuant to being at a border. And because the power of the government is so much higher at the border than even during a normal routine arrest, I don't think the logic quite flows. Modern cell phones as a category implicate privacy concerns far beyond those implicated by the search of a cigarette pack, a wallet, or a purse. The Supreme Court further noted later in the opinion that a cell phone search would typically expose the government to far more than the most exhaustive search of a house. Defendants have also pointed to broad latitude border officers have to search physical items, but comparisons to searches for digital evidence or contraband searches of other physical items are inopposite. The court's reasoning in Riley holds the same force when applied to border searches. Let me try that again. The court's reasoning in Riley holds the same force when applied to border searches. Okay, guys, the district court's decision basically comes down to the truth of that one sentence. That's like the entire linchpin of this decision, in my opinion. It's like whether or not that sentence is true. Does the logic of Riley apply to borders or not? Does the logic of Riley that says that cell phones are special because they contain lots of information and therefore it's not like searching other stuff, does that logic apply at the border when the power of the government is at its zenith at the border? I'm not sure the logic follows. I really want it to follow. I wish it would follow, but the power of the government at borders is so high that I don't think you can just map one onto the other. It's not as simple as saying it said it in Riley and we can apply it here. It's an upstream application. It doesn't quite map. And so like everything basically boils down to whether or not that sentence is true. And I don't think it probably is given the precedent that I know about. So as much as I wish it was, I don't think this decision is going to stand. Unlike a vehicle, vessel, or even a home at the border, there should be another comma in there or something. Unlike a vehicle, vessel, or even home, at the border, the data stored on a cell phone is distinguished from physical records by quantity alone. Basic searches, defined only as any search of an electronic device that's not advanced, can access content from space physically resident on a device using the device's native operating system. That is, even a basic search alone may reveal a wealth of personal information. Electronic devices carried by travelers, including smartphones and laptops, contain a very large volume of information, including sensitive information. Even in a basic search, agents can pursue and search the contents of the device using the native search function and available keyword search. This court does not dispute that a cursory search of an electronic device, a brief look reserved to determining whether a device is owned by the person carrying it across the border, confirming it's operational and that it contains data, would fall within the border search exception and not require a heightened showing of cause. However, the range of searches that the plaintiffs were subject to and the breadth of searches that continue to be permitted, even as basic searches under the current policies, are not such routine searches given the breadth of the intrusion into the personal information. I don't think so, man. No, I don't know. I think the Court of Appeals is probably going to reverse this, to be quite honest. The Supreme Court, I'm sure, will. So, yeah. No. Nice try, but it's not going to fly at the end of the day. It's just not. Since Border and ICE have adopted their policies in 2018, the electronic devices of some plaintiffs have been searched in what have been described as basic searches. An advanced search can generally reveal anything that would be discovered during a basic search. In addition to revealing data, an advanced search may also be used to uncover deleted or encrypted data and copy the information on the devices used. I think you probably could, on the case law, distinguish between the simple search and this more advanced search, because copying the data and that kind of stuff does seem way more intrusive than a typical routine search. So you probably could distinguish it on the case law based on that. But as to this simple search and just doing a routine search in like a search app, I don't know, man. Given the case law, and the power of the border, I'm not really finding the decision to be perfectly persuasive. On this record, and as the plaintiffs contend, the court is unable to discern a meaningful difference between the two classes of searches in terms of privacy interests implicated. The concerns laid out in Riley of unfettered access to thousands of pictures, location data, and browsing history would have qualified as a basic search, apply with equal force to basic and advanced searches, particularly as the device's native operating system becomes more sophisticated and most closely recognizes the capabilities of an advanced search. In light of the record, case law, and conjunction with the lack of meaningful difference between basic and advanced, this court concludes the agents and officials must have reasonable suspicion to conduct their search. All right, I'm done with this case. That's enough of this case. So that is the case of Ghassan al-Assad versus the Department of Homeland Security. In this case, we learned several things. First, that Border Patrol is conducting both basic and advanced searches of cell phones, laptops, and other searches. In basic searches, they are using the built-in operating system and built-in search function to search the phone for things that they find interesting. In advanced searches, they copy the phone wholesale and look for deleted phones and retain the data for later use. In either case, the plaintiffs have argued this violates their rights. They have cited the case of Riley, a United States Supreme Court case which held that pursuant to a lawful arrest, a routine search of a cell phone was excessive, and it did require a warrant. The district court here has applied that decision to the border. Unfortunately, I believe that this decision is ultimately incorrect. The power of the government at the border, given the case law, is so high that I don't think that the logic of Riley automatically applies, at least as it relates to the basic searches. Perhaps for the advanced searches, where data is being kept wholesale and copied wholesale, that would be something where the logic might apply. But as to basic searches to see if there's any contraband on the phone, I think that probably passes the muster of the Supreme Court's test, given the power of the border. Even though it didn't pass muster in the case of Riley, you can distinguish on the factual background of border versus arrest. And so we will keep track as this case moves through the system and see what happens next. Are they able to retain government data like the NASA employees? I mean, that's, fight amongst yourselves at that point, basically. It's like, in terms of that, in terms of who gets to keep what governmental data. Yeah, fight amongst yourselves. All right, guys. I left the funnest case for last, but I need a beer. So I'm getting a beer. I'll be right back. Yeah, diplomatic pouches are a whole set of category unto themselves. Yeah, the Border Patrol can't search diplomatic pouches. I believe, and I'd have to go back and double check, but I believe they can put it through an X-ray machine, but they can't look inside. And even that case was like major brouhaha over that because, diplomatic pouches are diplomatic pouches, but I think they can run it through an X-ray. But yeah, those are a whole other set of categories. If you're lucky enough to have a diplomatic passport, it's a whole category unto itself. Is it legal to have a diplomatic pouch without an authorization? Yeah. I don't know how other countries do it, but in the United States, they actually have different color passports. Like the traditional passport is blue. I'm pretty sure governmental passports are red. Or no, they're brown, I think. Yeah, governmental passports are brown if you're on official business, but diplomatic passports are black. Black. Yeah. You have a black passport, you're very important. All right, so let's find this case that I said was fun and see if it's as much fun as promised. If not, well, tough. Smurf berries, guys. Smurf berries. Well. For today's case, Hello everyone and welcome to Uncivil Law. For today's case, we have the case of Joe Young versus David Brady. In this case, Young parked his truck and was sleeping in a sleeping bed. A game warden came by and was suspicious. He thought that he might be hunting in violation of law. Now, what was he hunting, you might want to know? Well, illegal palmetto berries. I am not making this up. Berries. And so he wanted to conduct an arrest to see if this guy was illegally poaching berries, palmetto berries. So we're going to read all about these berries and how super important they are and how this game warden conducted this search, and read more about berry and berry theft and berry seizures and an incident where apparently there was a berry bust. I cannot make this stuff up. So let's get started with this. I have no idea what a palmetto berry is. I have no idea what it is. I'm a South Carolinian too. I have no idea what a palmetto berry is. I'm assuming it's not a palmetto tree. I'm assuming it's something else. Anyways, carrying on. The relevant facts are as follows. On August the 27th, 2017, Young parked his truck in a gravel parking lot underneath the bridge at Sidney Lanier Park and was resting inside of it. He had his windows up and a green-gray colored sleeping bag in the bed of his truck. Officer Brady parked near the truck and approached, asking Young if he was okay and asking him to roll his window down. At this point, Young waved his arms at Brady, indicated he didn't want to speak with him, and drove off at a slow speed. Brady walked back to his car and radioed that Young was pulling off from him. Young drove at most several hundred feet away to another parking lot in the park. Brady pulled up beside him less than 30 seconds later. After getting out of the truck, Brady approached Young, who was agitated, and confirmed that he was stopping him. Brady asked Young to get out of the vehicle, and Young inquired as to why. After about a minute of back and forth, Young got out of the truck and Brady handcuffed him. He reached into Young's pocket, pulled out his wallet, and ran the driver's license. After uncovering no outstanding warrants or other issues, Brady uncuffed Young and allowed him to leave. Young filed suit against Brady, alleging that while he was handcuffed, serious injuries occurred. Brady removed the case to federal court. Young subsequently filed a motion for summary judgment, asserting that the officer had no probable cause. Brady filed a cross motion for summary judgment, arguing that the claim was barred by doctrine of qualified immunity. All right. This is the part where it goes from normal to crazy. He argued he had reasonable suspicion to stop Young because Young had a large bag in the bed of his truck, which appeared to be the type used by illegal palmetto berry harvesters in southern Georgia during that time of year. It was the middle of the palmetto berry harvesting season. Apparently, there are special types of sleeping bags specifically for illegal palmetto berry harvesters in Georgia. Who knew? During the hearing, the court inquired as to what circumstances would make Brady suspect that Young was engaging in illegal palmetto berry harvesting. The counsel responded that Brady was suspicious of Young's sleeping bag, which he apparently suspected was a bag used to harvest the palmetto berries. He also pointed out that although no berry harvesting occurred in the park, harvesting generally occurred in southern Georgia during that time of year. Young responded that Brady had never mentioned the palmetto berries in any of his legal filings up to that point, and the counsel had violated the rules by failing to disclose any evidence relating to the palmetto berries until after discovery had closed. I promised you it would be a fun story, Ewan. I promised you it was worth the wait. The district court denied both motions for summary judgment, finding that Brady was not entitled to qualified immunity. It concluded that observance of an unfurled, flattened sleeping bag in the bed of a parked truck in a public park in the middle of the day is not particularly an objectified basis establishing a reasonable suspicion of criminal activity, no matter what berry picking season it is. I don't know what to say beyond this, guys. These are just the facts. This is what happened. Brady timely appealed. On summary judgment, a district court's denial of qualified immunity is immediately appealable if the sole concerns concern the legal decision. When an officer asserts qualified immunity for an alleged Fourth Amendment violation, the question is not whether the officer had an actual suspicion, but whether he had an arguable suspicion. In other words, we consider whether an official had a reasonable suspicion as an objective question based on the totality of the circumstances. Apparently, palmetto berries are used as a nutritional supplement for urinary and reproductive health. Noted. Yeah. These need to go in your book of legal one-liners, no matter what berry picking season it is. Yep. Whether an official has an arguable or reasonable suspicion is a question of law. We consider the totality of the circumstances in light of the experience and determine whether the officer can point to specific and articulable facts that support an objectively reasonable suspicion the defendant had engaged in a crime. This is off topic, but I feel like if Kansas v. Glover had read this, that decision would be a lot easier. But I don't know why we're having that discussion in Kansas v. Glover, but apparently we are for some reason. I don't know what's happening there. After careful review of the facts and after construing the facts in the light most favorable to the plaintiff, we affirm the district court's decision. While arguably reasonable suspicion sets a low bar, we cannot say that Brady's actions have cleared it. Nice. We conclude Brady violated Young's constitutional rights, specifically Young's rights under the Fourth Amendment, when he seized him. As a preliminary matter, Young was seized within the context of the Fourth Amendment when Brady approached his car for the second time because a reasonable person would not feel free to leave. The import of this conclusion is that, at that point, Brady must have had a reasonable belief that he had arguably reasonable suspicion to effectuate the investigatory stop. In other words, he must have reasonably believed that specific and articulable facts taken together with rational inferences support an objectively reasonable suspicion. Brady's argument that he had the requisite suspicion falls into three categories. 1. He suspected Young was engaged in illegal palmetto berry harvesting. 2. Young drove away from him when Brady first approached. And 3. Young was belligerent. We can summarily dispose of the third argument. Brady was required to have reasonable suspicion at the time he was seized, not thereafter. Therefore, the agitated demeanor is irrelevant. Now the court is going to analyze whether his belief that this guy was committing theft of berries in a park was based on any sort of reality. So let's analyze the deep contours of berry law. First, we are unpersuaded by Brady's argument that suspicions of illegal palmetto berry harvesting justified the seizure. His argument is essentially that suspicion was justified merely because Young was in the general region of the state where illegal harvesting occurred at around the time it occurred and had a sleeping bag in the back of his truck. It's about to get better, guys. Brady points to, among other things, an affidavit from Brian Claver, the chief law enforcement for the Georgia Forestry Commission. Claver's affidavit explains that illegal palmetto berry harvesting primarily happens around Dixon State Forest near Brunswick, Georgia, between August and October of each year, with a large percentage of the harvest occurring in August. Along with his affidavit, Claver submitted a Law Enforcement Division weekly report for the week of August 13th, the week before the seizure. The weekly report details a bust that took place on August the 14th, in which rangers recovered 1,800 pounds of palmetto berries near Waycross, Georgia. I always knew the berry police would come after me, man, but it finally happened. I don't know how, Marty, but they finally found me. Hope you're real proud of your berry bust there, guys. The report includes a picture of the bust, which shows brown and clear bags, some of which have emblems on them, stuffed with palmetto berries. You got to get that. You got to get that pimp shot with the illegal seizure. Some drug enforcement agencies have cocaine, some have marijuana, some have heroin, and you have a picture of your bags of palmetto berries. Outstanding. On what basis do we think that he was engaged in illegal berry harvesting? Let's see. Brady's main argument here concerns Young's sleeping bag. He argued that he believed the sleeping bag was the kind of bag used by illegal berry harvesters. You know, I'm considering a career of illegal berry harvesting, so I just like to know what kind of sleeping bag is best for my illegal berry harvesting needs. You know, is this the kind of thing that is like rated by REI, or, you know, is it the kind of thing I can get on Amazon reviews? You know, which sleeping bag is really best for my berry seizing needs? You know, I need a stakeout for the berries, man. It's all about the berries. What sleeping bag is going to work for me? I got to know. We conclude that this argument doesn't track with the events depicted in the footage from the body camera. It's nice to know we have body camera footage of this wonderful seizure involving berries. So berry, so juicy. Forget Brady. How does the lawyer handle it? He couldn't do it with a straight face. Look at my face. Look at my face. This is like, yeah. Both times Brady approached the truck, he obviously saw the sleeping bag lying on top of the truck bed. It was broad daylight, and Brady got within 3 or 4 feet of the bag. And although Brady's argument on appeal is that he needed to seize Young to further investigate the sleeping bag for potential palmetto berry harvesting, he got equally good, if not better, look at the bag moments before. I don't know how you investigate the bag for palmetto berry harvesting. How do you do that? I don't know. I need to know. In any event, we doubt Brady's depiction of the events in question. Why would you doubt this officer? He's clearly telling the truth. It's all about the berries, man. When he seized Young, that is, when he approached Young's truck for the second time, he did not so much as touch the sleeping bag. And quite inconsistent with Brady's later testimony at the summary judgment stage, the sleeping bag did not appear in the footage to be stuffed with palmetto berries. That's just how good the deception is. It is a blanket of shielding you. It's nothing but palmetto berries in the entire bag all the way down. It's palmetto berries sitting in there, I'm telling you. The officer knew. The officer knew. This sounds like the worst D&D session. I investigate the bag, roll a 1. Yeah. We determined earlier, and Brady does not contest, that Brady seized the Young by the second time he approached the truck. By that time, Brady had already been quite close to Young's truck, indeed close enough to trust the window. It was easily capable of determining that Young's sleeping bag bore no resemblance to palmetto berry harvesting bags. That presupposes these bags actually exist. In order to make a comparison, they would have to be a thing that exists. What does a palmetto harvesting bag look like? Should I be Googling this? I feel like I need to Google this. Hold on. Palmetto harvesting bag. Let's see. Oh, can I get online shopping here? Oh, no. See, shopping. Let's go. Let's go shopping. Oh, God. Okay, I got. I guess just a generic bag. I'm telling you, he was involved in the high life. He needed that sleeping bag. This little pansy bag isn't gonna satisfy his berry craving. Based on the totality of the circumstances, we conclude Officer Brady did not have arguably reasonable suspicion that Young was engaged in illegal palmetto berry harvesting. Very sad. Another court defeating an officer is just trying to do his job of protecting those sweet, sweet palmetto berries, man. Young's location in the general region of the state during the quarter of the year in which certain illegal activities takes place, coupled with an unfurled sleeping bag in the back of the truck, did not provide Brady with specific and articulable facts in support of his suspicion. Here, based on the totality of the circumstances, we cannot say that Young's short travel from the parking lot under the bridge to a nearby parking lot created suspicion. To that end, we disagree with Brady's characterization that he fled. The body camera footage plainly shows that he drew off at a slow speed. Well, he had to drive off on a slow speed. He was high on those berries, man. Parked a few hundred feet away from the destination, and immediately yielded to Officer Brady once he realized he was being stopped. Viewing the facts in the light most favorable to Young, Brady did not have suspicion to conduct the Terry stop. A reasonable officer at the scene would not have believed that illegal palmetto berry harvesting or any other crime was occurring based on Young sitting in his parked car in a public park with a sleeping bag on the back of the truck. I just figured it out, guys. He was the spotter. That was what he was. He was the spotter for his team of berry harvesters. So, he was there watching the scene, making sure he was the lookout. Look out for the guys. So yeah, he was the ringleader. He's the mastermind. A team of people engaged in berry harvest, Mission Impossible style. I'm telling you what. And so this bag was totally a berry picking bag, and he was totally engaged in it. He was there to be a spotter, look for those berries, and he successfully diverted the police officer's attention, this poor police officer's attention, while his co-conspirators got away scot-free, and the judge is none the wiser. What a shame. As his lawyer, I demand to be paid in palmetto berries. Young has thus met his burden of showing a reasonable jury could find that Brady violated the Fourth Amendment. Accordingly, we conclude the district court did not err in denying the motion to dismiss on qualified immunity grounds. So that was the case of Joe Young versus David Brady. I cannot make this stuff up, guys. A game ranger saw someone sleeping in a sleeping bag and thought that they were engaged in illegal palmetto berry harvest, which apparently is the thing that happened because they engaged in a palmetto berry bust where they got 1,800 pounds of those sweet, sweet palmetto berries. But unfortunately for the officer, the diversion was complete. He did not have enough evidence to conduct the stop of the guy because his bag appeared to be empty and he didn't realize it's just the spotter for his team. So, another berry bandit gets away. It's another criminal day, and it's really sad. But at least hopefully I can get a cut of these sweet, sweet berries for covering this case. Please give me a call, hook me up. I need those berries, man. I need those berries, man. That's the offer now, guys. Still there. Bye. Oh, yeah. Ocean 14, the Great Berry Heist. Yeah, that's basically where I'm going with this. Not even using the bag, mere possession of a sleeping bag. No, it was a berry picking bag, you fool. It was, yeah. So did you guys love that story as much as I did? I was great. I saw that one and I thought of you guys. I was like, the berries, man. The berries. I didn't know that they had game rangers for berries. I know they had game rangers for deer. I didn't know that they had officers for berries. Game warden. Game warden with DNR, Department of Natural Resources. He's a game warden. And his job is to look for berry harvesters. I don't know, man. This is like Great Berry Bandit as a title. I don't know. We'll think. I think like the Smurfs have got to be jealous. Maybe he was the lookout for the Smurfs. Maybe that was what's going on. He was a Smurf. He was captain of the Smurfs. He was Gargamel turned bad, or turned good, whatever. Anyway, so yeah. I wonder if the sleeping bag like had patterns of berries on it, palmetto berries. Can you get like a design in a palmetto berry pattern as a sleeping bag? That'd be cool. Maybe get my truck or you know, I'll have like the medallion hanging from my rearview mirror of a palmetto berry. Maybe a chain, gold palmetto berry chain, because I'm such a thug when it comes to that palmetto berry life, man. Good stuff. We're done with free streaming, by the way. So, you know, we can talk about whatever, because I'm not in a hurry to get anywhere. Let's see if there was any comments or whatever. Let's see. I had one super chat. That was very nice. Thank you for that super chat again. For the $10. That was well appreciated. Midnight Rose 07. Having your validation matters a lot. You know, it really does. You know, I was actually pleasantly surprised in the comments to my Citizens United video on Leonard. It, at least in my purview, seemed to be mostly positive. You know, you don't put out an opinion that bold and not expect to get some kickback. But most of it seemed to be fairly positive. Most people seem to think that, you know, I did a fairly good job presenting it. So I was pleasantly surprised not to be raked over the coals and actually have some validation. It was nice. Yeah. Yeah, Cody Sam said, I always wondered how people can be so stupid, have kilos of drugs in the trunk. They still run the red lights. I mean, it's like the least of the problems. The amount of stupid when it comes to criminals is like amazing. They get busted on the weirdest things. Cell phones are special everywhere that's U.S. soil. Well, that's part of the problem, Cody. It's like on the border, it's not U.S. soil. Like, this is pretty well established. You know, like even when you land at an airport, you know, in the United States, you're like still like not within. You know, you're in this quasi land because you're not past this security yet. So you're not like technically in the U.S. So you can be like deported just on a whim and stuff like that. So, you know, you're not really in the U.S. despite being on the U.S. soil. So, yeah, good times. Let's see. Palmetto berries are total pseudoscientific crap. Don't tell me that. I need my palmetto berries, man. I need them more than I knew what existed. I'm going to inject it into my veins. I'm going to freebase some palmetto berries. Give me some palmetto berries, guys. I'm going to become a palmetto berry abuser. I'm going to become a palmetto berry dealer. I'm going to lead to the entire downfall of my entire community. I'm doing this Walter White style. I'm going to get myself a basement. In basement, I'm going to make berries in there. Distribute berries. It's going to be a massive enterprise. Watch me, man. It's going to be great. Lance said, instead of asking for dime bag, the last pint or quart. It's very nice. Very good. Yeah, man. It's like, I need gallons. Gallons. I can't get that much stock on hand. What are you, insane? They're going to come get us. How are you going to get that off? Yeah. Kurt is the one who knocks, yes. Would your berries be blue? It's a good question, man. Yeah, my baby blueberries, palmetto berries. I mean, Palmetto State, like, blue is the color of the flag, right? So making them blue would fall very nicely in with the South Carolina theme. It's a gateway berry, yeah. It's like, all the comments were about palmetto berries. Yeah, yeah, pretty much. Palmetto for life. Oh yeah, I break for palmetto berry stickers. I love it. Yeah, no, I'm definitely getting some palmetto berries. Can I order them? Can I get them at Whole Foods? What? I want some actual Palmera berry though. I don't want like the extracted distillation. I want a pure, unadulterated berry. I'm gonna make it myself because only I can make the extract right. I'm gonna make some homeopathic stuff out of some berries. E1 says, I was looking up in the background. There's no pharmaceutical substance been found to be effective. There's some been effective, some others causing the equivalent of an overdose. Noted. Excellent. Yeah. Oh, Lord. Well, that's enough for today. That's what, 5 stories. At some point, I have to actually edit this. But thank you for your support as always. 27 of you, if you were watching, if you have not already, please like the stream. There's only 11 thumbs up, so 16 of you could give it a thumbs up. Just saying, that'd be nice. Make Ewan edit it for reasons. Black beef banned palmetto berries. Yeah. Matthew says, in regards to stuff before arbitrary and capricious, can DA not bring charges be disallowed? Can DA not bring charges be disallowed? We were covering that a little bit when was I covering that? I think I was covering it in the Supreme Court case dealing with the DACA recipients. But very rarely is the answer to that question. There are some very rare situations where a prosecutor can be ordered to bring a case, but most of the time it's discretion. But yeah, there's some things where it's Congress is very clear and the language is very clear, and a prosecutor can be forced to bring something or be forced to be removed or replaced or something. So it's rare, but it has happened. Yeah. Can you carry a syringe of epinephrine in case you OD on the berries? I don't know. Maybe make anyone know. Yeah. All right, guys. I think I've been joking around a little bit, so I'm gonna get some sleep and go work tomorrow. But thank you all for your support and love as always. I'm gonna make this stream unlisted, so all the people who weren't here can't find it. But all you guys who want to go back and watch the original should be in your history queue. But yeah. Until later, my friends. I'm gonna go out. Cheers and good night.